Good evening, and we'll call Judiciary Committee, House Judiciary Committee to order. Madam Secretary, please call the roll.
Evans.
Here.
Beat. Here. Elbrock. Here. Anderson. Here. Coleman. Davis. Here. Mackey. Reedy. Here. Riley. Here. Sauls.
Here.
Schroer.
Here. All right, 9 present. We do have a quorum. We'll now go move into executive session. I move that House Bill number 2005 be voted to pass. Discussion. Chair does have discussion. I have a House Committee substitute ending in .02C to offer. It's been distributed. I move for its adoption. Discussion. This is the one he talked about last week. Discussion on that substitute. Seeing none, all those in favor of adopting House Committee substitute for House Bill 2005 signify by saying aye. Aye. Opposed, no. The ayes have it. You've adopted the substitute. I move that House Committee substitute for House Bill number 2005 be voted to pass. Discussion on that. See discussion. Representative Shore.
Briefly, just want to comment.
Go ahead.
I want to applaud the sponsor of this legislation. He's been hard at work past several years on this one. And this year's gone as far to have 2 different avenues for this. So I'm hoping that as I heard the Senate bells ringing today, I'm hoping they're going to set their issues aside so we can deal with solid policy like this. You know, I've said it a couple years ago, growing up in St. Louis County, I always saw this big sign in St. Louis City that said, stop eminent domain. And as a little guy, I would ask my parents, what in the world is that? And I thought it was unjust in many situations, and I think this is a situation where eminent domain definitely needs to be amended in our state. So I'm hoping and praying that once one of these 2 avenues get on the floor, get over to the Senate, that they can set their differences aside, come back together, and work for the people here. I'm going to support your bill, gentlemen. Thank you.
Further discussion? Seeing none, Madam Clerk, please call the roll.
Evans.
Aye.
Beat. Elbrock. Anderson. Coleman. Davis. Mackey. Reedy. Riley. Sauls. Schroer.
By your vote of 6 ayes and 3 noes, you voted committee substitute for House Bill number 2005 be voted to pass. And I do need to also mention, if anybody is still here, at request of the sponsor, we are passing any committee hearing or session on House Bill 2517. Representative Riley's bill will not be heard tonight. Probably look for that again next week. I'll be talking to him later. I now move that House Bill number 1548 be voted to pass. That was the bill discussed last week by Representative Veet. Discussion on that bill. Seeing none, Madam Clerk, please call the roll.
Evans.
Aye.
Beat. Aye. Elbrock. Aye. Anderson. Coleman. Davis. Mackey. Reedy. Riley. Aye. Sauls. Schroer.
By your vote of 6-2, you voted House Bill jumped ahead one. House Bill 1548 do pass. I now move that House. Yes. I don't care. We can do it. Okay, do it again.
Mr. Chair, there was a little bit of confusion on that last one, and being a party of the prevailing side, I'd like to make a motion to reconsider the due pass vote on House Bill 1548, please.
Okay, is that a motion the chairman can grant, or do we need a roll call vote on the motion? Okay. It's been explained to me, one member I thought was on the next bill or a later bill. Chair will grant another roll call vote. Madam Clerk, please call the roll. Oh, we have to do a vote on that. I can't just grant that. Okay, so we're doing a vote on the recall.
Evans?
Aye.
Veet? Elbrock? Anderson? Coleman? Davis? Mackey? Reedy? Riley? Sauls? Schroer.
By a vote of 8-0, we do have now a recall. Any further discussion on the bill? Seeing none, Madam Clerk, please call another vote on the Representative Veets bill. Go ahead.
Evans?
Aye.
Veet? Elbrock? Anderson? Coleman? Davis? Mackey? Reedy? Riley? Sauls? Schroer.
All right, by your vote of 7 ayes, 1 no, you again voted to pass House Bill 1548. Now the chair moves that House Bill 1963 be voted to pass. That's Representative DeGroat's bill. Discussion on that. Seeing none, Madam Clerk, please call the roll.
Evans?
Aye.
Veet? Elbrock?
Aye.
Anderson? Coleman? Davis? Mackey? Reedy? Riley? Sauls? Schroer.
By your vote of 7 ayes, 4 noes, you voted 1 no. That's 1662?
1963.
1963 been voted to pass. I now move that House Bill 2590 be voted to pass. Discussion on that bill. Is that correct? We can come back. Yeah, I've already called it, so let's do that one. Discussion on 2590. I jumped one in the order there. Madam Clerk, please call the roll.
Evans?
Aye.
Veet? Elbrock?
Aye.
Anderson? Coleman? Davis? Mackey? Reedy? Riley? Sauls? Schroer.
By your vote of 8 ayes, 0 noes, you voted to pass House Bill 2590. Circling back to the one I skipped. It's 1662. I now move that House Bill 1662 be voted to pass. Any discussion? I do have a House Committee substitute ending in .02C to offer. It's been distributed. I move for its adoption. Discussion on the House Committee substitute. It was mentioned last week. Seeing none. I had also, pardon me, have an amendment to that substitute ending in .01H, been distributed. I move for the adoption of the amendment. Discussion on that amendment. That is the amendment mentioned last week, my mistake. Seeing none, all those in favor of adopting House Committee Amendment Number 1 signify by saying aye. Aye.
Aye.
Opposed? No. Ayes have it. You've adopted the amendment. I now move to roll House Committee Amendment 1 into new House Committee substitute and adopt the House Committee substitute. All those in favor signify by saying aye. Aye. Opposed? No. The ayes have it. You've adopted the substitute. And then we go to the consent after that? Okay. I now move that the House Committee sub for House Bill 1662 be voted to pass. Discussion. Seeing none, Madam Clerk, please call the roll.
Evans?
Aye.
Veet? Aye. Ellerbrock?
Aye.
Anderson? Coleman? Davis? Mackey? Reedy? Riley? Sauls? Schroer.
By your vote of 8 ayes, 0 noes, you voted House Committee substitute for House Bill 1662 be voted to pass. I now move that House Committee sub for House Bill 1662 be voted to pass by consent. Discussion on that. It does take a unanimous vote. Seeing none, Madam Clerk, please call the roll.
Evans?
Aye.
Veet? Ellerbrock?
Aye.
Anderson? Coleman? Davis? Mackey? Reedy? Riley? Sauls? Schroer.
Yeah, I've lost my place. 1662, go back to that. That's 8-0. By your vote of 8 ayes, 0 noes, you voted House Committee substitute for House Bill 1662 do pass by consent. We'll now move to public hearings. We will hear House Bill 1682, sponsored by Representative Brown. Representative, please proceed when you are ready.
Thank you, Mr. Chair. Thank you, committee members, for time and opportunity tonight to talk to you about, it's actually a House Committee substitute for House Bill number 1682 on eviction moratoriums. If I could, real quick, I want to read you the bill, and then I want to give you my explanation as to why I brought this bill today.
And just to clarify,
I'm
again, Chair will give you permission to proceed on the substitute, and it's a very short bill, so go ahead and read it.
Okay. And also, for the record, I neglected to say this, Chris Brown, District 16, which is the Northland of Kansas City, kind of between Liberty and Platte County. Am I okay to proceed?
Sure.
Okay. All right, so this bill, it simply says, no county, municipality, or other political subdivision shall impose or enforce a moratorium on eviction proceedings unless specifically authorized by state law. The reason for this, the federal government instituted an eviction moratorium starting in September of 2020, lasting roughly a year up until about August of 2021. The moratorium was done through the CDC, which is a bureaucratic agency within the Department of Health and Human Services. During the moratorium, landlords could not evict for non-payment of rent. And let me say that again, for a period of roughly about a year, landlords were unable to remove tenants, cannot evict for non-payment of rent. And keep in mind that most evictions, 90% of evictions are done for non-payment of rent. And I remember when this was happening, I was just kind of astounded by this. I'm like, well, how does this work? The purpose of renting out property is to receive rent. This moratorium, in my opinion, was certainly unlawful. It was a clear violation of contract law and property rights. Keeping in mind that mom and pop investors, people with like less than 10 properties or so that they are renting out, they constitute almost half of all rental units in the United States. In 2018, CNBC reported that 58% of landlords do not have access to credit and would struggle in an emergency. So the bottom line is, I think some people have a misconception about landlords, that the bulk of landlords are large institutional investors or large corporations, when in fact that's not true. Most landlords are small-time landlords that have scraped together enough money to come up with 3, 4, 5, 6 rental properties that they're going to use for their retirement, for their kids' college, whatever it may be down the road. And if some bureaucratic agency comes in and tells them for an extended period of time, and I promise you, nobody in the history of real estate, in my opinion, has ever purchased rental property, investment property, and in the back of their mind, they thought for an extended period of time, someone's going to come in and say, hey, you must have this tenant in this property for an extended period of time, and they are not going to pay you rent, and we are going to allow that. It is estimated there's around $30 to $70 billion in back rent owed to landlords as a result of the pandemic. Finally, the moratorium was lifted with the Supreme Court decision in August of 2021, Alabama Association of Realtors versus the Department of Health and Human Services. They said that the CDC simply does not have the authority to deprive landlords of their property rights. Subsequently, though, however, many states have instituted their own eviction moratoriums, such as California, New York, and cities have done the same as well, such as Cleveland, Santa Fe, Baltimore, Denver. Now, in all fairness, during the pandemic, when the eviction moratorium was put in place, there was money allocated for assistance with this. However, though, of the $50 billion that was allocated for rental assistance, some states didn't get 5% out the door. And the bottom line is it didn't get to landlords. And the bottom line is most landlords, they cannot go 3, 4, 5, 6 months without rent. Bank of America, Wells Fargo, they don't care that your renter is not paying rent. So the bottom line is this put landlords in an unfair situation. And we talk a lot about government or bureaucratic agencies picking winners and losers, and I certainly felt like that this was done unlawfully. And here is also a purpose for this bill. I fear that going forwards, in particular large municipalities with interest groups that put a lot of pressure on lawmakers, whether they be city council, whatever the case may be, that a municipality could put into place an eviction moratorium. And that's kind of the purpose to a degree behind this bill. So I would entertain questions.
All right, Chair will just, again, to clarify, I have one question. You're proceeding on a bill that basically says no political subdivision may place a moratorium on rent unless authorized by state law.
On evictions, correct.
Evictions,
Eviction proceedings, correct.
Yes. Okay. Other questions, Representative Elbrock? Go right ahead.
Good evening, Representative Brown.
Good evening.
We spoke about this earlier. I'm not going to get into you that much because obviously you're passionate about it. I do have a couple of practical questions, though.
Sure.
Do you know in Missouri what types of renters those federal laws applied to? Like how many rental properties they had to have to qualify for the federal moratorium?
What do you mean on the landlord side?
Like if you rented 1 or 2 properties out, would those federal moratoriums have applied to you?
Well, I think how they did it, and I could be wrong, but I think basically the money went to the tenant. The tenant was supposed to pay the landlord. And it's also from just talking to landlords within the real estate industry, in particular around Kansas City, I think what happened a lot of times is once that word went out about a moratorium, in mass, people stopped paying rent.
Yes.
And money they did maybe get that was supposed to go to their landlord, it went into their back pocket. And what a bad position a landlord would be in if you have to rent to somebody maybe for 11, 12 months, and then all of a sudden the moratorium is lifted. The courts have a backlog of eviction proceedings that they're trying to do. So that landlord, it may take them another 2 to 4 months to get somebody out. So just look at that. You're looking at well over a year that someone is potentially losing rent. Most people, in particular, like I tried to point out, the small-time investors, that's a tough financial storm to bear.
And you and I both, we're from the same place, basically.
Yeah.
You and I we're neighbors.
Yeah, for sure.
And I saw the same things on the news that you saw, and we heard the same stories, people not paying their rent for months at a time, big cities coming out with stuff like this. And you and I both looked at that, and there's nobody where I'm from anyway, that looks at a situation and thinks you get to live somewhere for free. Nobody thinks that.
Right.
None of my constituents believe that people ought to be able to get away with not paying their rent. And
Right.
I agree with you in that principle. But what happens when the courts themselves issue an order closing the courts for the pandemic? Because in a lot of cases, that's what happened. And the courts basically shut down their own selves because the courts are co-sovereign, right? So if the Missouri Supreme Court issues out an order and says, we're not doing any more hearings of any kind for the next 3 months unless you're looking at a capital case or unless you've been in custody for more than a year, everything's getting continued for 3 months, which is what happened in this last epidemic, now what we're dealing with now in the courts. When we get to that point where the courts issue out their own orders closing the courts, is this law going to have, is this law going to do any good? Because we're co-sovereign to the judicial branch, but if they decide they just want to stop having hearings, they can do that.
Well, I think the CDC, it wasn't the courts that stopped eviction proceedings, it was the Department of Health and Human Services. Now, if the Supreme Court comes out and says, hey, we're going to shut the courts down for whatever reason, that may be a little bit of a stretch. But if they did do that, the supremacy clause, I would say that's going to trump what we're doing here in the state.
Well, so in state courts, which is where evictions proceed.
Yes.
Right?
Right.
And the Supreme Court issued out an order in, I want to say last week of March 2020, that basically continued every case on their docket till the end of April.
Right.
And that included evictions. That included everything, everybody that's not in custody, everything that's not immediate and has to be done right away.
You were talking state Supreme Court, weren't you?
I'm talking about the state Supreme. Yeah, the federal Supreme Court doesn't have any jurisdiction over state Supreme Courts. And when they did that, nobody could proceed. So it wasn't as though evictions weren't being done in Missouri because of a federal CDC mandate, in spite of what a lot of people thought. It was because there just wasn't a court to hear the eviction proceeding.
Right.
Right. So this bill won't address that issue, correct?
Representative, that's a good question, and I don't have an immediate answer for you. I'm not an attorney on that, so I don't know. Maybe there would be someone that is going to testify that could shed some light on that, but Representative, I'm not sure on that.
I appreciate the inquiry. Thank you.
Yeah. Representative Short, go ahead.
Thank you, Mr. Chair. Thank you, Representative, for bringing this bill forward. I've got family, friends, former colleagues, former clients that are property owners, some that own a couple houses. I know there are a couple legislators, former legislators that own property as well. And this is on the top of their priority list. And I think you hit the nail on the head by stating that this is a property rights issue and a deprivation thereof. Further, I think that similar to an argument which my colleague and I heard when we first came in I think it was 2017, on the right to work bill. And those that were opposed to right to work brought up the fact that they didn't believe government should be infringing and superseding different contractual rights between two entities. And I think that same argument should convince those that held that position previously to support this bill. And I could be wrong, but to my colleague's point, I believe that this is not going to change any ways that the courts can continue cases or anything that they're automatically authorized to do by law currently, due to the last four words authorized by state law. And I think any changes, which again, this is the part I could be wrong on, I think any changes to their ability to continue cases or close the courthouses down or go electronic on WebEx or Zoom, I think that's authorized by the Missouri Supreme Court, if I'm correct. But I'm sure one of my colleagues on the bar will be able to correct me if I'm wrong. With that, I fully support this bill, and I think it should definitely be on the floor next week. I move that we just exec this thing out today. Thank you.
All right, that would take permission of the speaker, which we don't have yet. Representative Sauls, go right ahead.
Thank you to inquire.
Please.
Thank you. So you said something that was actually incorrect, and I think this is an important thing to get out there, and that is, this isn't a situation, these safer funds, right, which is the money that was given to landlords in this particular instance. It's not going to renters. It's not like renters are taking this money and buying big screen TVs. This money goes to the landlords, and in fact, landlords can apply for this. This isn't a situation that necessarily needs to be applied for by, now, renters can too, and ideally what you want is if you've got a renter who can't pay rent, then obviously you want them to apply for something like this so that it keeps them in the property. And this money, I think that is something that's important an important point to note, because it's not just going to the renters. It's not going to renters and they're not buying big screen TVs. It goes to the landlords. You can apply for it, and it goes to the landlords. Either renter or landlord can apply for it. So I think that's one important point that you didn't mention. But also, you can still theoretically evict. You could, during this moratorium, you could still evict. It just had to be based on some other contractual right? So noise complaints.
property
or
damage.
Property damage
Yeah,
was a big one.
absolutely.
Right, obviously, particularly in a situation like that.
Yeah.
I agree with the gentleman from Clay. Nobody expects that people get to live somewhere rent-free, but also, you know, if you're damaging property, then absolutely, you don't have a right to be in that property in that instance and also damage it. So I would agree with that, but I think that's just one important point, that it's not, under this instance, the landlords can still get this money if they apply for it. I've helped constituents do this. And I've been involved in this process, and I think that's just an important point that needs to be made.
Absolutely.
Okay. Thank you.
Further questions by committee? Seeing none. Anyone here to testify in favor? Come on up. Please state your name, leave the forum.
Good afternoon, Mr. Chairman, members of the committee. For the record, my name is Jason Zamkus. I'm a registered lobbyist on behalf of the Missouri Association of Realtors. I think the sponsor did a really good job of explaining the intent of this bill, and with that, I'd just like to go on record and support and answer any questions that the committee members might have.
Questions by committee? Seeing none, thank you.
Thank you.
Anyone else in favor of the bill? Seeing none, anyone in opposition? If you come up, state your name and also leave the forum.
Good evening, Mr. Chairman, members of the committee. Happy to be with you this evening. My name is Jeremy LaFavor here today on behalf of Empower Missouri. I want to first start off by thanking the sponsor. We had a great conversation today. I am not, and I don't think Empower Missouri is oblivious to the fact that people throughout this pandemic have experienced a number of exceptionally difficult hardships, and I don't think landlords and investors are immune from that hardship. That being said, the hardship of people being outside of their homes, you know, we have to weigh pros and cons, and sometimes the choice between right and wrong or good and bad or a yay and nay may not be as clear as we think. And when we look at the need of society and people to have homes and roofs over their heads and families to have a safe place to call their home, and the need to make sure that investors are made whole within a handful of months for their rental property. There are different needs, and for Empower Missouri's standpoint, we lie with those families and people that need to stay underneath a roof for a limited amount of time. Moratoriums are extremely rare, and they don't completely eliminate evictions. Eviction proceedings continued throughout the pandemic for breaking leases for any number of various reasons. It's non-payment is the issue here. We get that. So it's kind of a rambling diatribe there, but we get it, but we are citing, we believe, the need of people and families to stay together as a family unit and stay underneath a roof is for us a higher priority than that of the landlords being made whole in a short amount of time for that rent assistance, because there is federal and state rent assistance, and it's our hope that it gets where it needs to go. Happy to take some questions, Mr. Chairman.
Certainly. Questions by committee? Seeing none, thank you.
Thank you, Mr. Chairman.
Anyone else in opposition? Seeing none, anyone here for informational purposes only? Seeing none, that concludes the hearing on House Bill 1682. We'll now jump to a little bit out of order, House Bill 2160, sponsored by Representative Dinkins. Please proceed when you are ready.
Thank you, Mr. Chairman, members of the committee. For the record, Representative Chris Dinkins, District 144. Today I'm bringing to you House Bill 2160. This bill is actually just cleanup language from 2018 from former Representative Kurt Barr. He worked on this bill for several years, if any of you are around during that time. The language stated in Tier 1 that it was for anyone who had served less than a year. Tier 2 was more than a year, and so anyone that had served exactly 1 year fell into no man's land and were immediately put into Tier 3. And so I had filed that bill and up on the Highway Patrol seeing it and some others, they said that there was some other cleanup language that needed to be included in this. So we worked on that, and I know the chair has worked on another piece of language previously. I'm not sure if he has anything this year, but prior he had a big, large bill that had the same corrections in it. And so this is only doing some cleanup language. Some of the offenses were never listed in statute at all, and so they are in there, and making them an appropriate place for them to be on the registry instead of just throwing them into Tier 3. And then there were some other areas where the language was not consistent throughout state statute, and the Highway Patrol wanted that all fixed at the same time. So that's what we are doing, and with that, I'll take any questions.
All right, questions of the bill sponsor? Just a question or two by the chair. The sexual registry is, you and I both have learned, is a very complicated procedure, a complicated statute. Part of the problem is also that there are two different registries, one being the federal and one being the state, and how those intermix and go together is part of the complication. Another part of the complication is this registry can stretch back decades as far as violations are concerned. And this body probably does more modifications of sexual laws, offender laws, than any other single section. So the registry has to deal with multiple different definitions and different levels of charges as they change over the time. So this bill is an attempt to just clarify part of that confusion that is created both by the federal registry coexisting with Missouri registry, as well as the difficulty of defining these different statutes as they change over time.
Thank you, Mr. Chair.
Would you agree with that?
I agree with that.
All right, very good. Further questions? Yes, Representative Sauls.
To inquire briefly.
Go right ahead.
Thank you. So I see that you scratch out here the directly or through the clothing of touching. Is that, I presume that's your intent?
On page 2?
Yes.
Yes, that was a change that the Highway Patrol wanted clarified or changed to line up with other statutes, and I think we're going to have a witness maybe give some informational purposes only that can clarify some more of that.
Okay. All right. I'll ask them. Thank you.
Further questions by committee? Seeing none, thank you. Anyone here to testify in favor of the bill? Go right ahead. State your name. Drop off the form.
Thank you, Mr. Chairman, members of the committee. David Jackson, registered lobbyist, but here to testify on behalf of myself today and support. On the side, I volunteer for a reentry organization in St. Louis, and I've worked a lot with different sex offenders. And you meet a lot of people that say, I'm pro criminal justice reform, except for the sex offenses, and it's definitely has a stigma. And I know that when you uncover it, you realize that there are some people that are in, pretty tough situations sometimes that don't always fall in line with the perception that we see. And I know that it's not easy sometimes to take up this legislation. And so I appreciate the representative and the committee for, coming forward to correct some of these changes and try to make sure it's consistent with national standards and do what's right, because I know sometimes it's politically very tough, but impacts a lot of people sometimes that are sometimes put in the wrong bucket. So with that, I will answer any questions, but thank you.
Questions of the witness by the committee? Seeing none, thanks. Anyone here to testify in favor of the bill? Anyone here in opposition? Anyone here for informational purposes? Come on up.
Mr. Chair, members of the committee, appreciate your time. My name is Scott Sleeter with the Missouri State Highway Patrol Criminal Justice Information Services Division. I'm a program manager who part of my responsibility is to oversee and administer the sex offender registry here in Missouri. And with House Bill 2160 that Representative Deakins is put forth. Just wanted to be here for informational purposes to answer any questions. As she stated, it is to provide a little bit of clarity for registering officials and do some cleanup language from previous passage. So with that, I'll take questions.
Sure, and just a couple quick questions by the chair. The Highway Department actually does the registry, but also tries to assist local sheriffs in interpreting what can be some conflicting or difficult areas of the law.
That would be correct.
Representative Sauls, did you want to follow up?
Thank you. Just kind of curious, going back to that part about on page 2, have you read the bill, I presume?
Yes.
Okay. So on page 2, where it talks about, it strikes out the sexual touching of or contact with a person's body, either directly or through the clothing, and goes into touching of another person with genitals or any touching of the genitals, etc. I guess I'm reading that, and I'm just kind of curious as to what it would seem as though, and I'm sure there are, well, I just would like a little bit of clarity on that, if you could. Maybe,
Sure. When Representative Dinkins reached out to us to kind of review this, and in reviewing that, I came across in another statute that already had a definition for sexual contact that was actually different than the definition listed here in 589-404. And so it was really just to make sure that the definition remained consistent where it was defined in another place of statute as well.
Okay, and I understand that, and I think that's a good point. I'm just curious if there's any, I guess maybe I just need to review the statutes again and see, but I would think that would be something that should qualify as an offense.
Yes, there are many offenses in 589-414 within the specific tiers that do have a sexual contact component that would make them a registrable offense.
All right, thank you.
Further questions by the committee of this witness? Seeing none, thank you. Anyone else to testify for informational purposes only? Seeing none, that concludes the hearing on House Bill 2160.
Yes, I could. We will now hear House Bill number 2056, sponsored by Representative Evans. Please proceed when you are ready.
Thank you, Mr. Vice Chair. I am David Evans, District 154. This bill has passed out of the House almost unanimously the last 2 years, and again have had difficulty getting traction on small bills, but practical bills. This bill was proposed by a good friend of mine, Ray Williams, immediate past president of the Missouri Bar, who does a lot of guardianship work. In my past job, I did a lot of that too. Most guardianships in Missouri that arise out of juvenile court, the grandparents are directly involved and are seeking guardianship. That is a number one preference in juvenile court, to look to other family members when a parent is unable or unwilling or unavailable to be the custodian of the child. The law mandates that you look at immediate family members. So you see a lot of guardianships with grandparents, and typically those guardianships, the whole system, the juvenile court, the family court, have worked with the grandparents for often years. So you have a very deep and close understanding of who they are and their abilities and what they brought to the life of the children. This bill simply says in those circumstances you don't have to have another home study. As attorneys know, sometimes those can cost well over $1,000 and slow the proceeding down a month or two. A home study, you actually, to do it correctly, somebody is paid to go out to somebody's home. They do an interview. They look around the house just like any professional would. They may talk to neighbors. They would do background checks. So there is a fee involved in that. And again, This just adds grandparents to the list, like a brother or sister doing a guardianship would not have to have that report unless any party member asks for it or the judge on his or her own motion requires it. So we put that in there just to make sure that we're not trying to sneak anything by. Any party can still request and get the full home study if there is a questionable grandparent guardianship out there. And there are a few where children and grandparents are fighting against each other, and it's more of a custody battle than it is a true guardianship. So that's the nature of the bill, just to allow that expense to go away, that additional time to go away, and to benefit grandparents when it's truly a non-contested case. And with that, Mr. Chairman, I'll be glad to answer any questions.
Are there any questions from the committee for the bill sponsor? Is there anyone here to testify in favor of the bill, House Bill 2056? Is there anyone here to testify against House Bill 2056? Is there anyone here to testify for informational purposes? That will conclude the hearing. Seeing none. We are adjourning.